Let's begin a discussion of torts. A tort is defined as a private wrong. What does that mean? Think about it this way. There are certain rules imposed on all of us. We don't vote on them, they're simply part of our common law. And remember our discussion of common law from earlier. These rules may or may not have been codified into statute, but it doesn't matter. These are the rules that apply to all of us, regardless of whether we agree to them. You cannot, for example, simply steal the book of the person sitting next to you on the bus. What could happen? Well, there could be criminal liability, of course. You could get arrested, prosecuted, end up in an orange vest or something, picking up trash on the side of the highway, but that relates to criminal law, which isn't our focus in this class. Besides criminal liability, what else could happen? Well, you could be liable to the person whose book you stole. The criminal prosecution would be for the violation you committed to the public. All of us suffer when there is harm to any of us. The name of the criminal lawsuit would be People of the State of California versus Taylor. Let's say you're Taylor. But the person whose book you stole, and let's call her Martinez, could also sue for the private wrong that occurred to her. The name of that lawsuit would be Martinez versus Taylor. And it, quote, sounds in tort, not criminal law. Could you be sued twice for the same theft? Yes, as we discussed earlier, criminal and civil actions are separate and parallel. You can be sued for one and not the other, or for both. It is not considered double jeopardy for a few reasons, but one of them is because the parties injured are different. Public wrongs in the case of criminal law and private wrongs in the case of tort law. Why don't we see more tort lawsuits? Aren't there private wrongs being committed all the time whenever there's a private wrong, for example, a crime? Well, yes, of course. But, and here we get to the business end of things, in most crimes, the alleged wrongdoer isn't worth suing. The remedy you would get in a civil lawsuit is normally damages. The legal remedy, as you'll recall from an earlier podcast, and most criminal defendants are what's sort of euphemistically called judgment proof. They either don't have much in the way of assets, or you couldn't locate or attach those assets easily. So cocaine stockpiles simply aren't going to be the form of an asset you could reach even if you could find it. The important way to think about torts is to distinguish between intentional torts and non-intentional torts. Before discussing the distinction, let me tell you why it matters. At the risk of sounding crass, intentional torts may carry a bigger judgment. That's because of the remedies awarded for intentional torts. For intentional torts, you may get an award of punitive damages in addition to compensatory damages. Recall our discussion of damages from earlier, and recall that their compensatory damages are designed to compensate the victim. By contrast, the role of punitive damages is to punish the victim. You can get compensatory damages for any tort and for a lot of other causes of action, but by contrast, punitive damages are normally awarded only if you can show two things. First, that there was an intentional tort, and second, malice. Well, here we're briefly discussing intentional torts. And if you can demonstrate that the intentional tort was committed with malice, then the plaintiff could get not only her compensatory damages, but also her punitive damages. For this reason, if a defendant's conduct could be characterized as either intentional or non-intentional, there's a preference on the part of plaintiffs to attempt to characterize the defendant's conduct as intentional. As a practical matter, this is counterbalanced by the realities of insurance practices. Insurers insure only losses resulting from non-intentional wrongdoing. This means there's a benefit, if there's any liability insurance that might kick in to pay on the judgment, to characterize wrongdoing as non-intentional so that the plaintiff increases the probability of actually collecting on any judgment. To juggle these counter incentives, plaintiffs often allege both intentional and non-intentional torts, trying to cover their bases until the course of the litigation reveals which is more viable. What does intent mean in the context of torts? Be careful, there are some terms used in law where the meanings of words differ from their normal use in English. Intent is one of those. Intent for our purposes means purposeful. Intent does not require that there be some motive to harm. This is important. All the plaintiff must show in order to demonstrate an intentional tort is that the defendant committed the conduct purposefully, not that there was any malicious goal. Even innocent mistakes then could constitute an intentional tort if the conduct was purposeful. There are a few other variations of the definition of intent. If a defendant intends the conduct towards one person but actually harms another, this satisfies the requirements of an intentional tort under the doctrine of transfer of intent. Transfer of intent can also apply so that if one intends one tort but actually commits another, the intent gets transferred. What is important to remember then is that the intent requirement is satisfied by any purposeful act. It doesn't necessarily require that the defendant be proved to have intended the actual harm caused or that he intended to harm the particular victim who's suing. When thinking about intentional torts, consider that they can apply to your person. For example, assault or battery relates to your right to integrity of your person, of your body. There are contracts related to property, for example, trespass. Property can be both what we think of when we normally say the word property, like land, but it can also relate to anything that's capable of being owned. So if I were to ask you, let's say you're a 19-year-old college student, do you own any property? Typically in class, that answer gets a laugh and a no. But does she own her notebook? Does she own her laptop? Is that her cup of coffee? The answer is going to be yes to all of those. So yes, she owns property. So property can be real property or also what's called personal property or chattels. There are several torts related to property rights. So we have rights related to our bodies, rights related to our property, and finally there are torts related to our reputation. For example, defamation, invasion of privacy. And there are different rules for all of these to be discussed in separate podcasts, but just be aware that there are several different types of interests that are protected. Separate from our discussion of intentional torts is our discussion of negligence. By contrast with intentional torts, negligence and strict liability torts are not intentional. Negligence is the most important of all torts since it's the one most commonly alleged. And torts, for that matter, are the most common of all causes of action. More than 70% of all civil lawsuits include a cause of action for a tort. And that tort is more often negligence than anything else. The elements of negligence are that the defendant owed the plaintiff a duty of care, that the defendant breached that duty, or in other words, failed to act with reasonable care, that the defendant suffered damages, and that those damages actually approximately caused the plaintiff's loss. We'll be going into more detail on these elements in a separate podcast, but right off the bat, recognize that negligence is a non-intentional tort and that there will not therefore be any recovery for punitive damages.